Form 223 is called the Temporary Emergency Period Modifications Notice. It's kind of a mouthful, and frankly, most landlords don't like this form much because it reflects all the new laws that came into being on July 1st, 2021, as a result of the eviction moratorium. So the good news is this is not a mandatory form, and you don't have to use it. But the bad news is it's got lots of information in it that you need to know, and the tenants have a right to know as well. So it's your discretion on how you use it, when you use it, and you might just get it for your own well-being. Senate Bill 282 passed, making temporary statute changes to Oregon tenant landlord law. The emergency period is defined as April 1st, 2020 through June 30th, 2021. The following modifications will expire February 28th, 2022. So we're stuck with them for about 8 months. This is being recorded on July 2nd, 2021. So I'm going to just read what they are and maybe talk a little bit about them. Number one, tenants are granted a grace period to repay any rent utilities owed during the emergency period, that was the COVID moratorium, without penalties or late fees, and that lasts until February 28th. So they have that much time to pay back the COVID rent. You can negotiate a payment plan with them, and they are certainly free to make continued payments. But if they default on the negotiated terms that you come up with, there's no consequence. They owe it all, whatever the balance is, by February 28, 2022, and there's no collections or derogatories that you can use in between now and then against that rent owed. Number two is probably the most important part of this, and it's a little subtle, but it's important. Payments received from July 1st through February 28, 2022 by a tenant who owes charges that occurred during the emergency period must be applied first to the current rent before being applied to any outstanding, not only COVID charges, but any other charges. So what that says is that you could have done a repair last month for a broken garbage disposal that was caused by the tenant, and they owe you $250. If they send you a rent check or any amount of money, the amount of money they send you first has to be applied towards this month's rent. And any other balance, utilities, past rent, maintenance, whatever, has to be carried after the month's rent is paid. So that's an important little fact. It's different than the rental agreement normally says, which says gives the landlord some discretion on how they apply payment. But for this extended emergency period, all money comes in must be first applied to the current rent. Number three, housing providers may not report tenant non-payment of rents during this emergency period to consumer credit agencies. So if somebody didn't pay for 10 months during the moratorium, that's not considered a derogatory. You can't report it to credit agencies. Not only that, housing providers may not consider that delinquency as a delinquency when evaluating rental applications. So this gets a little tricky because if you're called from a landlord, from somebody else who's doing a rental verification on one of your past tenants who didn't make any payments during the COVID moratorium, you can't share that information. They don't really have a right to know it. It's basically that money is not owed or delinquent until February 28, 2022. Housing providers, number five, are prohibited from imposing restrictions against tenants, guests, or temporary occupants based on the maximum duration of a stay in tenant's dwelling and enforcing lower maximum occupancies than those established by federal, state, or local laws. So what does that mean? That means that during this extended emergency period through February 28th, 2022, tenants have the right to have guests and or temporary occupants, the law basically defines them as the same, stay in their unit that are not financially responsible tenants, not on a rental agreement, as long as it doesn't exceed the maximum occupancy guidelines, which the rule of thumb for that is 2 per bedroom plus 1. So if I have a 3-bedroom house that 2 people rented, but they have family or friends that they want to stay for the next 6-8 months until February 28th, I must allow them with one caveat, and that is this. As housing providers, we may require that they sign a temporary occupancy agreement and that we can screen them at least for some basic criteria, but we can't screen them for financial or credit standards. So if they have some serious historical problems at other with other rentals verification, for example, we may be able to deny them. But the bottom line is that the law is stating that tenants have a right to allow people to stay in their unit through the next several months until February 28th. Where did that come from? Well, if you remember this little thing called the Oregon wildfires that put a lot of people homeless, the state legislature, in their wisdom, in the 2021 session, felt that those people shouldn't be denied a safe place to live if they could stay with friends or family members, and those are the basis of what temporary occupants are. But there's no way that a landlord can screen to determine whether or not the temporary occupant happens to be a fire victim. It's just that's the impetus behind that statute. And why do you want to know this? Well, this is the power punch. Penalties allowed to tenants for housing providers equal damages of 3 months rent, along with actual damages and attorney fees, defense to eviction for housing providers' failure to comply, ability to seek injunctive relief to regain possession of the premises, fines for retaliation that are increased from 2 months rent to 3 months rent, or 3 times the actual damages incurred by the tenant. And actual damages is a creative writing mechanism for lawyers to say that whatever we can package into it and make it sound like it's your fault, we're going to charge you for that. So it's almost like tort law, right? It's not quite, but it's very similar. So bottom line is that the tenant protection laws are strong. They have some meaty language behind them to make you think twice before not completely adopting and accepting them in your rental units. So the last piece of this form is the disclosure, and this came about from a bill, Senate Bill 278, that says if a tenant becomes delinquent in current rent anytime between July 2021 to February 2022, before I can file for eviction, before I send the notice or along with the notice of termination to pay or quit, this disclosure has to be given to them verbatim, and it says that they have the right to stay in the place for another 60 days if they prove to the landlord, they give evidence that they've applied for rental assistance. And if they've applied for rental assistance in the next 60 days, they don't get the money, the landlord can then continue with the eviction process. And they can't keep using this. This is a one-time shot. They can use it at any time in between now and February 2022, now being July 1st, 2021. But they can use it only once for a 60-day stay. If they don't come up with the assistance money, then there is a fund that the landlord can get the 60 days paid to them for that grace period, for that safe harbor period that the tenant got while trying to apply for the rental assistance. So told you you'd love this bill, or this form. And what's it called? Temporary emergency period modifications notice. Do you have to use it? No. When do you want to use it? Whenever you choose. We want to put it out there for your benefit as a need to know.